Hi, I'm Dana Sparks, broker with Maximum One Greater Atlanta Realtors. And today's contract tip has to do with title issues. Got a call from an agent working with a buyer day before closing, and they get a message information from the closing attorney that there is a cloud on title and the seller can't convey good and marketable title per the contract. So again, this is day before closing, and what happened was the agent sent a termination notice on behalf of the buyer so that the agent could go find the buyer another house. The buyer had just sold their house and had to be out by this weekend, so they have nowhere to go, and they have already closed on their house. They had occupancy till Friday. They are packed up, ready to go. So the agent thought it was in the best interest of the buyer to go ahead and terminate the contract so that the agent could go find the buyer a new house. Several issues we have. Closing date is not scheduled, and the buyer terminated prior to the closing date. Yes, it's a title issue, and wait till you hear what the title issue is. It's a doozy. Nevertheless, in both contracts, both the GAR contract and the RE Forms contract, the seller has, through the last agreed upon closing date, whether that be the closing date or any extension thereof, to clear up any title issues. So here's what the contracts say regarding good and marketable title and a seller conveying property with that title. In the GAR contract, it does specifically state that the seller warrants at the time of closing that the seller will convey good and marketable title to said property by limited warranty deed, subject only to zoning, general utility, sewer and drainage easements of record as of the binding agreement date, and upon which the improvements do not encroach. And 3, declarations of condominium and declarations of covenant, conditions and restrictions of record as of the binding agreement date. And 4, leases and other encumbrances specified in this agreement. Buyer agrees to assume seller's responsibility in any leases specified in this agreement. So the seller warrants that the seller will convey good and marketable title. Then again, in the GAR contract allows for a unilateral extension by either party just based on specific issues. One of those specific issues in the GAR contract is title issues, and it specifically states right to extend the closing. Buyer or seller may unilaterally extend the closing date for 8 days, and that's another issue that we've discussed in a previous video, upon notice to the other party given prior to or on the date of closing if 1, seller cannot satisfy valid title objections, excluding title objections that can be satisfied with a bond or payment or money or bonding off of which. And B, do not prevent the seller from conveying good and marketable title as that term is defined within the contract. So in the GAR contract, the seller has, through the date of closing, or the seller or the buyer for that matter, can exercise the unilateral extension in order to have some time to clear up any title issues preventing the seller from conveying good and marketable title. In the RE contract, if you're binding under the RE contract, same thing. The seller warrants that seller shall convey to the buyer good and marketable title to the property by limited warranty deed, free and clear of all mortgages and liens, except the property shall be subject to taxes not yet due, payable, and all other encumbrances, zoning ordinances, easements and restrictions of record as of the acceptance date, which in the RE forms, as you know, is the same as the binding agreement date. Good and marketable title shall mean title which the title company licensed to do business in Georgia will insure at regular rates, subject to only standard exceptions. Then the RE form contract goes on further to state where it talks about, and this is in the GAR form, all of this is stated in the purchase and sale agreement, F20. In the RE forms contract, this is all specifically laid out in form RE1, which is the standard terms for purchase and sale. So it's not the actual purchase and sale agreement. And as you know, as an agent in Maximum One, it is our policy that if you go binding on the RE Forms contract, you must print out these standard terms and reference them and attach them as an exhibit for this exact reason. So further in the standard terms on the RE Forms contract, it goes on to state duty to condition under condition of property. It talks about duty to inspect. Basically it says both the buyer and the seller have the duty to inspect everything about the property. One of those items specifically delineated is the title. And then it goes on to talk about default. So basically, if a seller binding under either contract is unable to convey good and marketable title at the time of closing, then the seller, at that point, then the buyer has the right to terminate the contract and either get the earnest money back or follow one of the other remedies in the contract. So here's the issue. The issue is, and again, don't forget, there's no unilateral extension in the RE Forms contract. That's only a provision in the GAR contract. So here's the issue. We are now in a mess because let me tell you what happened to the title, why the seller cannot convey good and marketable title. The seller was an investor, bought the property on the courthouse steps by foreclosure, fixed it up, it was a flip, turned around, and is ready to sell it. What this closing attorney found, however, is the previous owners, previous to this current seller, it was a married couple, and the husband passed away, but the couple had title as tenants in common, not title with rights of survivorship. So what happened is the husband's portion of title, the husband's half of the title, went to the heirs. The wife, the current wife's part of the title to the property, got foreclosed upon. So there is not good and marketable title. This current title insurance will not insure over a title where the foreclosure bank didn't foreclose on the entire title. Is that not crazy? So does this seller have some issues ahead of him to clear up title? More than likely, yes. However, our buyer terminated prior to the closing date or any extension of the closing date by unilateral right. So the seller does not necessarily, so the buyer basically defaulted on the contract, and the seller does not necessarily have to release the earnest money to the buyer. So what does this mean for you as an agent? A couple of things. Number one, if you are working with either a buyer or a seller, and that property has been conveyed to that current owner, if it's an investor or an estate, absolutely you need to ask some very serious questions about how that current owner of that property got that property. Are there any title issues? If it was a property purchased on the courthouse steps, what type of title search was done? How far back did that title search go? If it is an estate issue, we've talked about estate issues plenty. Has it been through probate? What type of title did the previous owners have? Was it title, if it was a married couple, was it title with rights of survivorship, or was it title as tenants in common? So don't wait to ask these questions of title until right before closing. Go ahead and be in touch with the closing attorney, especially in these situations. If it's an investor situation where the investor is selling the property, or if it is an estate issue, and go ahead and get that title search started immediately. Thank you so much for watching. Again, I'm Dana Sparks, broker with Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.